Welcome once again to Lehto's Law. Here's Steve Lehto.
This video might be a little longer than usual, but it's an update to a story I did before, and there's a lot of information here. But remember the boneless chicken case out of Ohio, where a guy went to a restaurant, ordered boneless chickens, was eating said boneless chickens, and got a piece of a chicken bone lodged in his throat, wound up in the hospital, extremely serious injuries, and filed a lawsuit. And the lower court, the trial court, said that not that the guy's case is weak, they said he doesn't even get to present it to a jury, we're going to throw it out. And that's what we're arguing about here. We're not arguing about whether or not the guy's case is $1 million case or $1 trillion case or a $100 case. We're arguing about whether or not he's got the right to take that to a jury. Most people I've talked to have said that he should get to take it to a jury. So when the ruling came down, it went all the way through the system and wound up at the Ohio Supreme Court. The Ohio Supreme Court actually said that boneless, when describing chicken, doesn't describe the nature of how many bones they have in them, but describes the manner in which they're cooked. I'm not making that up. And so I have in my hand here the most recent opinion from the Ohio Supreme Court, because they actually reconsidered the ruling. Now, some courts can do this, and a lot of courts are asked to do this. When they make a ruling, if they make a ruling that is so wrong, a party can ask the court to revisit it and basically double check their math. And this right here is the opinion announcing that they're going to stand by the previous ruling. And again, it's a very, very close call, but the majority opinion, okay, talks about how we really shouldn't be reconsidering previous decisions that often. It really should be rarer. Therefore, we're not going to even, and again, it was a close vote. I believe it was 4-3, 4-3. So 4 judges or justices of the Ohio Supreme Court have decided that we're not going to revisit this. Our previous ruling stands. So this is a lengthy opinion. I'm not going to read all of it, but I'm going to read some of the highlights. The case is called Berkheimer versus REKM LLC, and this is the motion for reconsideration, which has now been denied. And so there are several opinions concurring and dissenting here. And the opinion written says, reconsideration is unwarranted in this case. In the rare exception, rather than the rule for this court to grant motions for reconsideration, this court has the authority to grant motions for reconsideration filed under the rules in order to correct decisions which, upon reflection, are deemed to have been made in error. But this judge says we didn't make any mistakes. And in fact, he goes, it basically looks like instead of pointing out mistakes we've made, more people are upset by the fact that the media is going crazy about this case, and we can't just reconsider cases because the media thinks we're wrong. So part 3 of his opinion says, we are a court of law, not a court of public opinion. And he talks about how, number one, these reconsideration motions should be considered rarely. I wish to emphasize that decisions on motions for reconsideration like this one are not and never should be based on newspaper articles and writings by non-lawyers who have not reviewed the entire judicial case file or applicable case law. And by the way, I am not a non-lawyer. I'm an actual lawyer. So I'm one of the voices in the chorus saying that this opinion of theirs dismissing this guy's case is ridiculous. So he points out a case that says, it is assumed that judges will ignore the public clamor or media reports and editorials in reaching their decisions, and by tradition will not respond to public commentary. So he concludes by saying, the mere suggestion that rulings on motions for reconsideration should be in any way based on newspaper articles is improper. And he's getting at the fact that among the filings that were made in this case, some people did include articles and mention things about what happened in the media. So now that's the main opinion, and the case is dismissed, right? Well, the dissenting judges decided to dissent and write this up. So one judge wrote, months ago, this court received unprecedented media attention after it issued an opinion in what should have been a simple negligence case. Now, you might say, but Steve, they're not supposed to pay attention to media attention. The judge is pointing out that the media attention is actually evidence of something else. That opinion prevented the appellant from exercising his constitutional right to a jury trial by disingenuously defining the word boneless to mean you should expect bones. The majority's opinion has been rightly subject to ridicule. If there was an Olympics for sophistry, the majority's opinion would certainly have taken the gold. The majority blatantly orchestrated the desired result by usurping the jury's traditional role as a determiner of facts. This is exactly the type of activism self-described conservative justices purport to disdain. So this judge then points out that they're not just ridiculing them because they don't like the result. They're ridiculing them because the result flies in the face of common sense, and common sense is something that the jury is supposed to bring to a courtroom. And the question always is, would a jury find in this guy's favor? Could they find in his favor? And that's actually the standard. We'll get back to that. But I want to point out that the guy puts a footnote in here, and the footnote's quite lengthy, and says, derision has been the predominant response. A random sampling of comments to any article describing the decision is heavily slanted against the majority. Even neutral observers have mocked the majority's opinion. The Associated Press's article about the case, viewed millions of times, was published under the label oddities in all caps. A legal blog that presented an otherwise impartial account of the case concluded by stating, remember that chickens don't have fingers. And comedians have had a field day. For example, Lewis Black commented that saying boneless wings can have bones is evidence that we have lost all sense of reality. Stephen Colbert, when discussing the majority's ruling that boneless wings can have bones, asked, what is the point of anything? The headline for Above the Law's blog discussing the case was subtly snarky. Boneless wings can have bones, declare committed textualists. And this is just a sampling. So here's the thing. Without a doubt, this case carries profound implications for all Ohioans. Among the biggest problems with this decision is that it causes people to lose faith and confidence in the impartiality of the justice system. The Ohio Capital Journal's headline to its article about this case read, Ohio Supreme Court majority ruling that boneless wings can have bones is an embarrassment. TV station quoted a defense attorney saying, in New York, I'd like to think that there aren't a lot of judges that would be so boneheaded. At least one member of the General Assembly wants to enact legislation that requires the court to issue decisions that pass a common sense test, calling this case one of the most obvious cases of legislating from the bench possible, and adding that common sense and logic must not matter to the Supreme Court majority. All that seems to matter to them is shielding billion-dollar corporations from lawsuits when their negligence hurts people. And he goes on and on and on and gives all these examples where pretty much everybody is going, look, we're not saying the guy should necessarily win the case, but to say he loses because boneless doesn't mean boneless is absurd. So the trial court dismissed the case on summary judgment. The Court of Appeals affirmed, and a majority of the Supreme Court, affirmed the Court of Appeals. So the Supreme Court of Ohio reviews decisions granting summary judgment de novo, which means that they take a look at the whole case and pretend blank slate, what do we got? Summary judgment can be rendered only when reasonable minds can come to but one conclusion, and that conclusion is adverse to the party against whom the motion for summary judgment is made, and the party being entitled to have the evidence or stipulation construed most strongly in the party's favor. So for the purposes of a summary judgment motion, one side gets in and goes, Your Honor, they have not got enough evidence to win the case. And they stand up and go, we've got this evidence. Now, how strong is this evidence? Well, for the motion purposes, the court is supposed to go, let's take every inference possible and give it to those people to see if they could win at trial. Is it possible they could win at trial? All of these courts and the judges ruling against this guy are saying he could not win. There's not enough there. He could not win. He could not win. So this justice is pointing out that all of this noise in the media is evidence that reasonable minds can differ about the conclusion of this case, because that opinion is bolstered by the abundance of commentators and commentary agreeing with the conclusion reached by the dissenting justices. So the guy goes on for a few more pages on this, and he's pointing out the point where, he is clearly showing that it's not even a close call. It is way, way off. But one thing that the other dissenting opinion judge wrote is he points out that if the court can simply invent a new definition for a word, because trust me on this, and if you don't believe me, stop the video right now and go pull out a dictionary and look up the word boneless and see what the word boneless means in a dictionary. Do you have a dictionary, Andy? Hey, I got an idea for you. I got a dictionary right here. And I'm going to tell you right now, I did not open this dictionary today or yesterday. I simply am doing this because I know what it's going to say. And you go here, there's the word bone on page 383. That's a good number. All my Mopar guys are agreeing with me on that one. And I see the word bone, bonefish, and boneless. Without bones, destitute of bone. Without bones, or destitute of bone. Page 386, Oxford English Dictionary. This right here is the high court of the English language. And you can look it up in any dictionary you want. It's going to say boneless means without bones. So this court said, no. Boneless means a style of cooking. Now, I don't know that anybody ever said that or heard that before these guys said it. But the point is that they have now just simply decided to disregard a word that's used in everyday language in America. And the dissent points out that if they can ignore the meaning of this word, that means they can ignore the meaning of any words in anything, including, big words that differentiate certain things. Like suppose there's a series of things and it says and at the end. Can they disregard the and turn it into an or? Because that completely changes some statutes. And that's an example that the dissent gives. And so I want to be as clear as possible on this. I am not saying that this guy necessarily would win if he got in front of a jury. I'm not saying it at all. I'm saying I believe he's entitled to his day in front of a jury. And if a jury comes back and says, we don't give this guy anything, they don't have to explain themselves, by the way. They don't have to write an opinion. They can just choose to do that. And if a jury does that, I look at that and go, oh, okay, jury did that. Unless I sat through the entire trial, I can't second guess the jury. But the fact that you're entitled to a jury trial is something that most people assume, go, oh, yeah. A jury will decide this. See, judges are supposed to issue opinions and rulings on matters of law. Matters of fact are for the jury. And so the weird part here is that several judges at different levels have all said he can't get in front of a jury even though there is something in his boneless chicken that shouldn't be there if you're going to call it boneless. And again, remember that most dictionaries say boneless is without bones. Not mostly without bones. Not primarily without bones. But without bones. Without bones. So the sad part is that this appears to be the end of this guy's case. And like I said, I'm not saying that a jury has to give the guy money. I'm not saying the jury's got to do anything. I'm just saying the guy ought to at least get in front of a jury and tell his case. So the Ohio Supreme Court, sadly, majority, has now just decided to double down and underscore their previous idiotic ruling. And the rulings have been called all kinds of things. I've run out of adjectives to describe it, but I've been practicing law for 33 years now. I've handled a lot of cases. I've even had cases dismissed on summary disposition, which is what we call summary judgment in Michigan. I've had a judge say, Mr. Lehto, is not enough here to go forward. Your case is dismissed. I've had that happen before. I have. And there were a couple times I kind of agreed with it, a couple times I kind of didn't agree with it. But that's what appeals are for. However, I never had one this mind-numbingly stupid And so if you want to, you can read it yourself. It's only 14 pages. There is some legalese stuff in there, but the footnotes are fun. So again, it's Berkheimer versus REKMLLC. And sadly, the guy doesn't get to tell his story to a jury. And that's all he was asking, and that's all we were asking. But there you go. So the Ohio State Supreme Court can rewrite the dictionary, and they can tell this guy he doesn't get in front of the jury. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I love deadlines. I love the whooshing noise they make as they go by.